Right, I'm in the slightly embarrassing position that I think I meant to be introducing myself. So, Ben Weinberger, why don't you just come up and introduce all of us? Thank you.
That was a cop-out.
Yeah, yeah.
Are our microphones on? You know you have to be up on stage with us as well, right? All right, so we're going to hopefully not put you to sleep, but I will threaten now what I tend to do when I present. I do take pictures of the crowd, and if you're sleeping, I will tweet it. Be forewarned. So I'll introduce myself. I'll let everybody introduce themselves rather than me destroy exactly what their jobs are at their firms. I'm Ben Weinberger, for those of you who don't know me. I see a lot of unfamiliar faces in the crowd, actually, interestingly enough. I'm a lawyer. I'm also a former law firm administrator. I'm a recovering IT director, if that counts. And with that, I'm going to pass it over to my fellow recovering IT director, recently recovering IT director, to introduce himself next. Dan, you're next on the list, so we're going to go in order up there.
So I thought we were going to go to Jonathan next. Yeah, I'm Daniel Pollock. I was CIO or IT director at DLA Piper. I haven't yet decided whether I'm retired or just recovering.
And then we could go with Ian.
Morning, everybody. Ian Evans. I'm the managing director of OneTrust, formerly co-founder of a company called AirWatch.
And last but certainly not least, Jonathan.
I'm Jonathan Friedman. I'm CTO for Howard Kennedy.
There you go. With that, we have a clicker here. Yay. So we're going to do audience poll. We thought that would be a good idea to keep you awake. Kind of not kidding on that. So if you go to live.voxvote.com and put in that pin, we'll give you a second for everyone to do that. We're not going to do a poll just yet, but we have 4 different questions in there that are thankfully related to what we're talking about today, which of course is everyone's favorite topic at the moment, GDPR, yay, and cybersecurity. Uh-oh, why do I not advance? Hey, there we go. All right, so these are the general topics we're going to talk about. I thought just for the fun of it, so I could advance slides, we put some of the questions, sub-questions on each individual slide, so you're not staring at the same screen over and over, as exciting as that may be. So why are we going through all of them now? Really? I didn't touch it. There we go, yay, okay. I'm going to step away from that clicker. Hi, fellas in back running the slides. You want to go to maybe our 3rd slide somewhere, which has the first topic we're discussing? Operational impact? Yeah, it is. It's magic. How's that working out back there? Sorry, we got an hour. I mean, an hour for GDPR. Good times. That's almost as much time as your clients give you to get them compliant, right, Ian?
Go live in an hour.
All right, so let's go back to the first slide. Can we back up, please? I'll be your best friend. Back. There we go. That's the first slide I want. The operational impact of GDPR. So with that, I'm going to ask the panel questions. Let's talk first about you guys. I'm going to start with Jonathan on this one. What was your GDPR experience at your firm, since you're the only guy here left actually working in a law firm at the moment? Tell us about how it went down.
Yeah, I mean, we ran it as a joint project between IT and risk and compliance. Like all of these things, try to take it outside of IT, because of course as soon as you hear someone from IT banging on about data protection or something like that, nobody listens. So the important thing was to take it outside of IT, because I think the firm understood risk far more than they would understand anything technology-wise. So we ran it primarily as a risk-based project, and the input from IT was more on the sort of cybersecurity and technology side.
Is it the same for your firm, Daniel? I mean, is it something that you had to own or someone else in the firm?
It was. It was a project that originated within IT, but we managed to transition it into more of a business project where the overall program manager was actually housed within risk. Yes.
Yeah, I know talking to firms early on with this, it's kind of felt like every other project, it just got dumped on IT. I see a lot of nodding heads, kind of an IT project. There's technology involved. But it is something really owned by, I know that GC, a lot of firms I talked to, got involved, because if you have a proper risk program, you recognize it's broader than just technology. So that being said, I'm curious, And Ian spends a lot of time talking to firms specifically about GDPR. In fact, when we were talking on the phone, was it just a couple weeks ago, he mentioned how he had a firm phone him up literally on the 20th of May, something like that, asking him to help them go live in time with their new GDPR project. How'd that one work out?
I think they contracted with us. So it's kind of crazy, because when you look at GDPR that's taken 2 years to go into force, and now that day passed on Friday. By the way, I hope you all enjoyed Friday. There are a lot of people out there celebrating that maybe that was behind them. But interestingly, that people were still phoning us, and this isn't small organizations. These are super large national companies or multinational companies telling us that we were holding up their program in May if we didn't assign a resource and get them live by the 25th of May. And I think that maybe severely underestimated the task ahead of them.
Is everyone in this room, by the way, everyone GDPR compliant?
Huh.
Yeah. At least they're honest. We got that going. For those paying attention.
I don't know if you know, I think the LA Times is offline in Europe at the moment. Is that right?
Yeah, has anyone tried to access any sites like that? I was trying to access
There's quite a few sites down at the moment if you're a European.
We were just talking about that, because I think Ian and I need to go back home and send some subject access requests to all of those sites that we can no longer access from here. Because it'd be good fun to find out what they've got. And I know I had an account. I used to live in LA years ago. So I have an account at LA Times. Curious what information they hold on me, now that they're clearly not compliant. So, we were talking about this when we had a little bit of a call beforehand, and there's definitely a general feeling of burnout. Somebody actually, I forget which one of you guys mentioned it, referred to as GDPR PTSD, because there's been so much droning on about GDPR. Let's talk about that. Did you find, in conversations each of you had, did you find people just didn't get it, or they weren't getting it, or they didn't grasp the extent of it?
I think the extent of it's been mishandled. I mean, as a company, we're only 2 years old, so we implemented GDPR, ISO 27001, and SOC 2 all in the same 6 months, right? So we were really done with the whole thing. But it's again, it's processes and extending those. Most firms that we talk to have done something. They've got spreadsheets. The problem is when you approach this from a spreadsheet perspective, you end up with tens and tens of spreadsheets. So nobody's thinking about it from the incident and breach procedure. They're not thinking about it, what happens when I only get 72 hours to find out what might have been the case. So we can all build something on spreadsheets, and GDPR is a human issue, not a software issue. But when we think about operationalizing, which is what this is about, how do I carry on running my business and keeping these records evergreen, making sure that the data is cleansing itself, because our businesses don't stand still. And then taking that perspective so that it's just part of our normal operational running of a business. All this change management that goes on in our company, we know that happens. So I really don't think a lot of people grasp that, and I was still, in May, interviewing candidates to join our company saying, how's your GDPR program? And they said, yeah, we had to find somebody that knew about it. The majority of people I spoke to hadn't figured out that their organization was going through that sort of change, and there was some guy in the business somewhere scurrying around trying to get Article 30 records together.
So I'm going to ask Jonathan next before I go to Daniel, because yours is more complex. But Jonathan, can you give us an idea, what were the conversations you were having like at the firm?
I think as Ian said, it was like, for those of us, for the people on the GDPR project teams, we're living and breathing as GDPR every day, day in, day out for 2 years. And of course, I think to an extent, you don't realise that outside of that, most normal people don't think about it in that way. So I think for a lot of people, it didn't.
Thank you.
Not just within the firm, but when I talk to other people from other firms and other businesses, for anyone not on a GDPR project team, I don't think it figured that highly on their radar a lot of the time. It was, there's this GDPR thing going on, and I've sort of heard about it, and yeah, I think that for a lot of people, I think if you weren't actively working on it, a lot of people didn't really know about it.
And that raises an interesting point, which I want to go to Daniel to ask about, because I know I live here. Don't let the accent fool you, but I do travel back and forth a lot. And when I talk to people in the U.S., half the time, not a clue, never even heard of it, which I found surprising, because I had to explain to them exactly how that works, although they haven't quite figured out how the GDPR police are going to come and get them when they're not compliant, but that remains to be seen. How did you, because your firm is global.
Yeah.
You must have had these conversations with people that had no idea what you were talking about.
Well, yeah, absolutely. I can't extrapolate from DLA Piper's experience to everyone, but if I attempt to do so, we did a very good job of getting everybody to understand and classify data so that we knew what we had. We then spent a lot of our time writing down plausible statements about how where we were was a reasonable place to be and what we might do next in future. We were not driven by the terrible fear that somehow on the 26th of May the ICO was going to start slapping fines on people. And the ICO and other enforcement agencies have made pretty clear that that's not what they want to do. And to that extent, I think, sorry if I'm answering a slightly different question, Ben, but I don't think it's like the year 2000. Once we all survived and woke up on the 1st of January 2000, we thought, great, the year 2000 problem's over. I think it is very different. I think that actually the enforcement and compliance regime starts from the 25th of May rather than ends. And if DLA as a complex global business is typical of businesses, there's still a long way to go on that journey, whilst at the same time recognizing that there are core things that had to be in place for that date. But lots and lots of lack of awareness of what personal data was. Yes, absolutely, very difficult.
Yeah, and this is especially, like say, going back to the discussions I've had with people in the U.S., you know, they've been doing this for a while. The same ways we here have had laws for, you know, years now that the ICO has been enforcing around privacy. So it's still, I found it surprising people had this lack of awareness of it. But I can tell you it's gotten to the point where I've spoken to a lot of our peers, IT directors at firms, who say that, you know, they're so burnt out by the whole thing because it's got to the stage where they've kind of given up on it. They've got to a certain point where they feel, let's wait and see what happens. So I don't know what each of your firms is doing, but I think there's a certain amount of pause that people are taking and waiting to see who gets busted first, which, you know, maybe that's not a healthy attitude. So that being said, I want to bring up, we have our first question. Let's see how this works, because they're going to have to flip to a different laptop and back to bring up our polling. Who's running the laptops back there? Anyone? Anyone? Can you flip to, there we go. So did everyone find this site okay? So you can vote. I think if he just hits start, there you go. You got 60 seconds on the countdown to quickly vote. And our question, you know, are you responding to your opt-in spam? I can tell you that I'm not. I'm curious how many of those I'm going to be immediately removed from lists. Yeah.
It's got to be the best way of cleaning up your email.
Absolutely. Although I think it's a missed opportunity. You take all those ones in your that came to your inbox, or mine wound up in clutter or got tagged as spam, literally, and send a subject access request to them and find out what they have on you, and then exercise your right to be forgotten. See how that works out for them.
Interesting.
Wow. I'm actually surprised at the number of people who said yes, they're actually doing something. That's a pretty healthy number.
Yeah. Who are these suckers? The 27.5.
Yeah. Anyone want to raise a hand for that one?
Sorry.
I think I did respond to one of them. Most of mine are from estate agents. We want to stay in touch. I don't want you to stay in touch. Yeah. So honestly, this, you know, I honestly thought it'd be almost 100% in that red right there, because, and this is just from somebody who's now on the vendor side of the fence. I don't know how you guys dealt with this, but, you know, I'm responsible for our marketing functions as well at the company, and it's curious, you know, how exactly do you handle that? Because for your firms, you have to think about that. Do you send one of those stupid messages, which I think at a certain level showed a lack of understanding for what the current law is, because that very well may have been a violation of the current law to send those ones out, asking people to respond and opt in. And by virtue of sending it out to ask people to opt in, you pretty much destroy your marketing lists right there. Given the fact, I mean, I'm surprised this many. Actually, okay, quick show of hands, though, for the people who did opt in or opt out. How many of you actually opted into anything? Yeah, see, this is what I mean. You look at the room this size, I saw about 6 hands go up. With that kind of a rate, the number of people that actually respond and opt in, you'd be marketing to 6 people. Yeah, not really a good way to spend the dollars.
But is that a problem?
It's a problem for a company that otherwise is able to engage with its customers.
But when you see organizations out there, and I've spoken, this became pretty vogue in the last 4 months, I would say. How do we handle consent? Nobody really worried about consent. 4 months ago, I spoke at a couple of marketing conferences, and we talked about consent and preferences and how do we handle that. So most of these emails you're receiving, you're actually reading them. Because if you read them, they don't follow GDPR guidelines anyway. So they're bundled. There's an imbalance of power. You can't get to the service that you've got unless you opt in. So they're really denying you that service. And I think that's the challenge, is how do people understand that? So I get the whole thing, let's get rid of anybody that we don't want to be talking to. But I'd rather market to 6 people that wanted my services than 100 people and try and choose the 6. And I spoke to an enormous company that said, we have 8 million records in our database and they're ours. We don't need consent, they're ours. This was only a couple of months ago. And I said, well, how many of the 8 million do you care about? And they said, 8 million. And I said, well, if only 1 million care about you, then it's 1 million. Surely there's a, you know, along with operational sort of reform under GDPR, we've also got to think, why do we target 8 million people when only 1 million people care? And if it's 1.1 million that come to the website and they decide to subscribe, then I'd rather have that list. It's like the estate agents. They're going to keep on emailing you long after you bought a house. But you need a break once you bought a house, right? You know, you go on live in it first for a while and then figure that out. It's like the recruitment agencies that email you and ask for your consent, even though they've just placed you in a company. So it's almost false to do that.
Yeah, I understand that. I just think, you know, when you're looking at it, and I don't know if we have any business development people here, you know, for firms today, but, you know, certainly there's that concern that lawyers have. Oh, I need to stay in touch with all of these clients or potential clients. So when you limit it down, year 6, you know, they're in the mind of the lawyer, they're going, well, is that going to be enough to pay my mortgage?
But there should be, you know, for a law firm, you should have some contractual arrangement.
Yeah, absolutely. The same way as any business really probably does, which is why a lot of those email messages were pretty ridiculous regardless. So if we go back to our slides, flip to the other.
Just a quick comment, Ben.
Yeah.
2 things struck me last week. 3 actually. One was, gosh, I didn't realize that I had an electronic footprint in all of these different places, organizations that I'd long since forgotten about. Second, I tweeted about this last week. Did every organization in Europe have an SA crisis and had to pull an all-nighter to get the emails out? This became law 2 years ago. It was extraordinary how many of these emails came out last week. The third thing was horrifying. Apparently, it's still okay for direct mail organizations to send you paper spam as long as you're not named on the address.
That's correct, yeah.
So direct mail organizations, including the Royal Mail, I'm sure, see this actually as an opportunity to increase the amount of paper that you're going to get. I don't know if that's going to happen, but that would be quite a bad thing. I've got quite enough pizza menus for my house.
I agree with that, actually. I know somebody who actually suggested that email doesn't work as well. Let's send everything via paper, and just the cost associated with that, let alone the annoyance of that stuff when it goes straight to at least I recycle it at my house. I don't know what you do with yours, but mine goes to recycling. So let's go to the next topic, since we've talked about as much as GDPR. I don't see anybody nodding off just yet, which that's the topic I thought would have lost them. Let's talk about, more importantly, how we deal with that sensitive client data and what we do with technology around that. Because this is something, I just from looking at the vendors that are out there in the hall today, there are several here that absolutely have software they'd love to sell you. They have solutions that they'd like to talk to you about around how to guard your sensitive data. But the first one we talked about as a group was, you know, have you implemented pessimistic security? Does everyone here know what pessimistic security is? You know, traditionally in something like your document management system, optimistic security meant that anyone, once they walk in the door, has access to everything. Whereas pessimistic, no one has access until it's explicitly granted. And this is an issue, since it was mentioned earlier, the Panama Papers, that wouldn't have been as bad of a breach had that firm, Mossack Fonseca, implemented something like pessimistic, where, you know, not everyone had access to everything. So this is something that's a hot topic for firms. A lot of firms are doing this right now, trying to go through the project. But let's talk about with our panel. Where are you in that as far as your firms go? We'll start with Jonathan.
It's an interesting one. It's something it's very actively in progress at the moment. It's tough because it's a shift in mentality. It's a shift in how you handle things like knowledge and precedents, and you sort of get into starting to anonymize precedent documents and changing business processes around it. I think similar to GDPR. We took it as a risk-based thing. So you start off with the areas of the business that we perceive were the highest risk, the most sort of visible, highest risk sort of departments and teams, and building it out from there. Something that we're trying to find the right speed. It's something we're very actively doing, but doing it at a speed where you can apply the pessimistic security, but without breaking anything else.
Yeah, and that's a good point. That's a big concern. It's a big fear. I noticed on the list of attendees, there's a lot of knowledge management people here, and that's usually where the pushback comes, right? The lawyer's worried about, if I can't get access to something I might possibly need, that's going to be a problem, aside from any of the other logistics of doing it. How did that play out in your firm?
So, well, DLA, I think pretty much a lot of firms, had a mostly optimistic security model restricted by country. I've got no doubt that as DLA moves forwards to the next generation of DM solutions, that will become more pessimistic. Just speaking more generally, to make a couple of points, financial services clients are generally amazed if and when they discover that their documents are visible to more people than just the individual who's working on the matter. And I think that client pressure will, and is already, you all know, I'm sure, it will drive and is driving an increased pessimism, certainly on a client-by-client basis. But I just want to link back to the artificial intelligence point earlier. I do worry about KM professionals' views of the world in that it must be tough for you guys because you want to widen access. But I think there's an opportunity for AI potentially to keep enterprise search and optimism alive whilst auto-redacting and auto-anonymizing stuff potentially on the fly. And I think that there may be quite an interesting KM opportunity there for those vendors that exploit that.
Yeah, I don't think anyone's got anything like that today, but I agree. And it comes along also, I guess, with trying to understand what the content is, with categorization, some sort of automated system around that.
Absolutely.
Yeah, I think you raise a really good point with that. A lot of firms, I don't know how many of you actually speak to your clients. Those of you who are at law firms, you talk to your clients. But this is something I do to find out, what their expectations are. And it's, to your point, I find it shocking. A lot of firms have no idea that as of now, not even GDPR, but before then, there's plenty of other regulations in place that affect them that would require what you call least privilege access to things, which ties into this whole concept of pessimism or need to know. And there was a law enacted in the U.S., in New York, the New York Department of Financial Services, I wrote an article about this one, enacted a Cybersecurity Regulation that pretty much required, that it mandated that only those who needed access to the information would have access to it, and it applies to all their law firms. So you think about any of your firms who have financial services clients, think about your financial services clients. If they have any presence whatsoever within the state of New York, so, and most of them do, right? We're talking about banks, we're talking about insurers. They all have a presence in New York City. So they all fall under this regulation, and therefore your firms fall under that regulation. And how many of you are actually compliant? I'm going to throw it out there and say from who I've talked to, less than 3%. That's the number I've heard. Less than 3% actually are compliant with that today. So if it's not GDPR related, which also has its similar regulations in there, maybe the state of New York is going to be going after people at some point. Same problem. Is this, with conversations you've had, that come up?
I mean, yeah, less so. I mean, we're still very focused on trying to get people to understand the data they have and identify that PI more than anything else. So we don't really step into this. This falls under more of a security implementation that we would normally see.
Right.
But interestingly enough, we also have a similar approach around privileged information. So we secure that down. The rest of our information, we essentially trust our organization to manage that sensibly. But it all goes through various systems that log file movements, changes, deletions.
Trust the way the Panama Papers Trust worked, or the Paradise Papers Trust worked, or
we're a software company, so the level of damage you can do.
We trust our partners. Yes,
it's small in comparison.
Yeah. But that's an interesting point, because I think that's one of the responses I've encountered in talking to different partners at firms. Well, we trust our partners. But then again, I point out to them there's been so many high-profile incidents. And if there's something that's a challenge at your firm, if you're still struggling with getting people to understand it, there have been very high-profile incidents where it was an insider. Almost all the biggest breaches lately have been insiders, where it was somebody who they trusted, who had access to the data, who then used that data inappropriately. I mean, there were cases of Wilson Sonsini, a very large firm out in California that represents Google and a lot of the Silicon Valley companies. They had somebody who was actually reading time entries to figure out what was going on, and then did insider trading based on time entry information. So it's things you don't think about that people have access to. Or there was a firm in Delaware. I have a friend who's actually the COO of that firm, and it was before his time. But there was somebody, and it was someone in IT, interestingly enough, was looking at documents within the DMS and then insider trading based on that. And then my favorite case I love is a company called Cinevel, which I don't know if you've seen, is American Semiconductor, was competing in the same space, and Cinevel was a Chinese-owned company, actually paid somebody within American Semiconductor to give up some sensitive intellectual property. I think they bribed the guy with something like $1 million or something, $1.5 million, and it wound up being billions in damage to the company. I mean, decimated the company. So it's that easy. Got a question there, Mr. Hunter.
Yeah, question for Ben and also for the panel.
Based off of the concept you're talking about, and you just gave that example, specifically, hypothetically, you have a client in Hong Kong, and how do you end up going about some of the data security perspectives within Hong Kong, understanding it's a different region, that region is, of course, continually changing at the moment. What would be some of your strategies there, because that's a region that could potentially be a model for other regions around the globe, different perspectives on privacy and data?
That's a good question to point to you for, Daniel.
Well, I'll just give a general answer, which might not take you very far. I do think that law firms are going to have to think much more about segmenting their worlds. I think that all of the global law firms have built their promise and their competitive position on we are a fully integrated organization, our lawyers can log in anywhere, work anywhere, and access anything. I think that those days are going to draw to a close, or at least come towards a much more restricted situation, so that there will be country by country, and perhaps even within country by country, restrictions on what people can do and what can be accessed. Hong Kong, of course, is a very difficult one, because depending on which side you flip the coin, it's either a Western jurisdiction that's concerned about Oriental issues, or it's an Oriental jurisdiction concerned about Western issues. And I think that, again, to generalize, it's very easy for Western law firms to talk about the threat from Russia or China. I can tell you that if you're sitting in Beijing or Moscow, possibly even in the same firm, you're thinking about the threat from the US and the UK. And so squaring those things is going to be increasingly difficult. But I'm sorry that I can't give you specific guidance, but I think it will lead to levels of segmentation that we haven't seen before.
I think that's a good point, and it's something I guess everyone in the room has to think about in the context of how they're implementing these things in their firms, especially as we see the increase in law firm merger activity. It becomes more complex, so firms that today may not be multinational will probably in just a few months be multinational. My last firm is now a multinational firm, and I think that's going to be a continuing problem for at least people who have to figure out how to implement that. So that raises a good point. I know in the interest of time we want to get to the next one. We've got other stuff we can talk about here if there's a key point that we wanted to bring up. I'm going to make mention of this bullet point here. The reality is, at the end of the day, with any of this data, the hardest thing for lawyers to do is talk to their clients, right? I mean, any of you who work with lawyers in your firm, they have a real trouble talking to their clients about bills. They have a trouble talking about security on content. But those of us who then get lumbered with all of the audits, find this a challenge. You know, but with client data, it really is the client who's the ultimate owner of that data. So it's about getting your lawyers to talk to the clients, and perhaps the clients say, you know what, it's okay that everybody in that practice group or that region or what have you can see my data. And maybe the lawyers can give them a good song and dance to convince them that it's okay to look at that data. It may not be, but at the end of the day, that's a very valid defense to, oh, well, best practice is to lock it all down. It's the client's choice, really. You know, this is a discussion I imagine you guys would have at some stage, you know, when talking to clients or in your firms. I want to bring up the next poll. We have another poll question, again, just to make sure everyone's still paying attention. And then that gives me a chance to take a photo and see who's sleeping while we're doing the next poll question. I don't think he's paying attention to the presentation and back. I appreciate it's probably not very interesting for him. Can you flip us to the, thanks. There you go. Okay, so in your firm, and this, take this, you know, hopefully you can read this okay, but have you implemented, have you locked down your data? Can everyone read that in the back? Is that readable? Do I have to read out what the answer choices are? You can see it on your phone as well. All right.
Perhaps only the firms that have, perhaps only the businesses that are running a document management system should answer this, because others might think.
Well, no, because you can apply it also in
Okay.
other ways, I think, yeah?
Sorry, Ben.
I'm just saying.
You are photographing the
I am. I don't mess around. It's not, oh, he has to press play on the question back there. Did you click start? Yeah, there we go. Now you can answer. You have 50 seconds. Daniel, hum the theme song to something while we're waiting.
I could try and sing the car share song from last night. How many of you watched car share? No one.
Please don't.
Ooh, look at the numbers. No, number one, it's pretty close to what I'm hearing from people, at least at the moment. Wow.
It's a big shift.
Yeah. Ooh, look, a couple people quickly answered just to mess with my statistics. We're going to prove that Ben guy wrong. 7%. I know a couple of you just voted that way because you think you're messing with me. No, so realistically, look, this isn't surprising. This reflects a lot of what we heard as well. I think, you know, there are certain practice areas. I know I was at a firm years ago where we did a lot of gambling work for casinos and stuff, and we had to have that locked down. And this is literally more than a decade ago, so I understand that. Does that look surprising to anybody else?
No, I agree with you. I'm guessing the 39% is people with information barriers and other
limited
smaller
lockdown.
lockdowns.
Yeah.
Yeah.
That number at the bottom is also disappointing as it is, not even remotely surprising. A lot of firms that, you know, I'm sure plenty of you want to, but haven't been able to. So hence my comment earlier, though, about a lot of people I know taking a wait-and-see approach to see who gets busted first. I think that's kind of where that's gone. Firms are not exactly the quickest to change. All right, let's go back to our slides and advance to the next one, please. Ooh, the laptop went to sleep. There we go. So let's talk about cyber terrorism. I thought I saw a couple of vendors out there who had products in that space. Has your firm experienced an attack? Gosh, who do I ask on the panel about that? Mr. Pollack, you want to talk a bit about that?
Well, the short answer to the question is I don't work for a firm, so the answer is no.
A firm you've been with has...
Yeah, well, what can I say? A number of people have heard me talk about this. Elements of it, of course, are confidential. It was a very profound incident. We in DLA Piper, when I was part of the we in DLA Piper, we wanted to use the cyber attack that we experienced in June 2017 as something that we wanted to help the industry to learn about. And so we've tried to share as much information about that as possible. At the time, we thought that something very, very bad had happened, actually the worst thing that can happen to an organization is to lose data or to have data exfiltrated. And that is not what happened to DLA Piper, I'm proud and pleased to say. But we've seen with Mossack Fonseca the impact of a significant data compromise. I think that truly is an existential event. And I think that the lesson for the industry is that the key question that everybody should be asking themselves is my client's data well enough protected? Question 2 is, how do I stop myself being attacked? And then question 3 is, how do I recover from an attack? I think that we answered questions 1, 2, and 3 pretty well, actually, last summer. But I would encourage everybody to think about putting more investment pounds and more investment dollars in the protection of your data. I think also organizations need to accept that it's not a question of if, it's a question of when and how often you are going to experience a cyber attack. I think there's a glib anecdote that there are only 2 types of law firms, those that have experienced a cyber attack and those that think they haven't experienced a cyber attack but actually have. There are attacks happening all the time. In terms of some of the lessons that I would draw from last year that I think are of use to the industry as a whole is make sure that you understand the difference between business continuity and disaster recovery. That is an absolutely crucial piece of understanding. Disaster recovery is how you bring things back to life once they're dead. Business continuity is how do you continue operating your business while you wait for disaster recovery to take place. Most organizations do not understand the difference between those 2 things, and we certainly learned a lot of lessons about that distinction in that period. And another lesson that I would throw out is when you are thinking about your disaster recovery and contingency planning, make sure that you ask the question down to the most fundamental level. If I ask you, what would you do if you had a disaster? Most organizations will say things like, well, we have dual data centers, and if we lose one, we've got the other one. So I would just encourage you to just ask the question, what if they both go? And just take your DR and BC planning down absolutely to ground zero, because there's certainly a lot to learn in that space. I think I'll restrict myself to that.
Well, just to add to that, the whole concept of just because you have these duplicate data centers, if one gets corrupted and you're busy replicating to the second one's corrupted too. So that is something a lot of people don't talk about. That actually was one of my areas of expertise, business continuity planning. But I want to ask Jonathan, because we were talking about this with regard to having a plan for managing risk. Tell us what you do at your firm.
Yeah, one of the things we've been trying to do is actually to try to make it real for people. So we started off, it's very easy for someone like me, someone in information security, to stand up and go, you must change your passwords, and you must do this, and you must do that. I think people are very used to seeing those kinds of messages, used to seeing and ignoring all those kinds of messages from anyone in IT. So what we've been doing is actually a series of war games, probably best describe it as, and live hacking simulations. So for example, doing with a lot of our GDPR, to go back to the first topic, with a lot of our GDPR preparations and building it into cybersecurity, we started doing sort of lunchtime hacking demonstrations. So, you know, you get everyone into a room, you provide free food so that they come, and we actually say, right, you know, it's very easy for us to stand here and say, this is the sorts of things we have to do for cybersecurity. We actually said, well, let's see what happens when you don't have those kinds of policies. And we did, we used a malicious Word document to take over a laptop and took photos of someone with the webcam while they're sitting there being the volunteer from the audience and that kind of thing. But actually use that to then sort of build awareness, but to say to people, look, this isn't just us in the firm going on about it, that this applies to your home lives as well, and it's about protecting not just client data at work and staff data at work, but about your personal information at home and families and this kind of thing. So to kind of make it real for people, to sort of say, you know, look, here's some real hacking going on. Let's show you what this really means and what we can really do. You know, sort of broke some passwords and go, you know, sort of go, look at this. Well, here's some passwords. Here we have a list of 27 million passwords. It takes a minute to run the password cracker against that. But then what we started to do was to then, I think we built it into our business continuity planning. So up until that point, a lot of the business continuity planning had been focused on what if the office burns down? What if there's a flood? What if there's a transport strike? And of course, it was kind of ignoring the idea that some kind of cyber attack, a ransomware attack or a DDoS attack or something is far more likely than the building burning down. So the next step was to then start building that into business continuity planning. So we got our business continuity group, which is made up of obviously representatives of business services and the managing partner and sort of representatives from across the business. And we actually gave them some cyber war games and scenarios. So we did a scenario of data has been uploaded to Dropbox and leaked from there, and a scenario of a ransomware attack, and actually sort of played it out, you know, sort of as a timeline to kind of go, right, business development, what would you do? HR, what do you need to do? This is what IT would do. And then to actually try to get people thinking in that way about what would we really need to do. And then we use that to start really actually enhancing our incident response planning. Because I think up until then it had been a kind of, you know, you sort of write this sort of template-like document where you kind of go, this is what we will do, and we have a checklist, and we have this. And when you actually start exploring it and go, well, what does this actually mean? Like, yes, we have this checklist, but does it mean anything in real life? Or could you actually do something useful with it? And then when you actually run it through a scenario and you try to follow it, you go, no. So we actually then have to almost go back to the drawing board and write the document again, and this time in a way that's far more useful.
Yeah, one of the key lessons that we took out of last year is perhaps best illustrated by, it's a quote I think from Eisenhower, and I'm not sure that this is a fully accurate quote, but he said something like, plans are useless, but planning is everything. There is no substitute for actually playing through real thought about scenarios. Simply ticking a box that you've got a plan doesn't actually get you anywhere.
I'm going to say related, and what I think is a better quote is the Mike Tyson quote. Everyone has a plan until they get punched in the face. And Daniel got punched in the face last June. So let's bring up our next poll, if we can, please. Flip to the other screen. And while he's bringing that up, I'm going to just put a quick plug in for a couple of things. I recently got involved with something from the National Cybersecurity Center here in the UK, that there's a specific initiative for legal. There's a group of people who are sharing information. It tends to be the information security officers of
Guys, you need to
firm.
press start.
Oh yeah, click start please. But if that sounds of interest to you, a lot of firms are already involved. I'd highly recommend you get involved in it. It gives access so people are sharing about these incidents. And then the other one is, and make sure you're answering this while I'm babbling away. There's, for those of you who are familiar with ILTA, International Legal Technology Association, they have a Legal Sec initiative, which is actually very good. They have an event in DC in June. But again, really a lot of good, useful information for sharing around a lot of this security stuff.
Wow.
Yeah, I don't find this stat surprising either, honestly. When Jonathan talked about his extensive plans and everything he's doing, I think he's doing more than most. Well, clearly he's doing more than most. I just know from my own experience, I've been in a few firms where we really, we had plans, we didn't test them. So I think you're ahead of the curve. It doesn't mean that everyone else doesn't have to catch up, but there we go. 40% have a plan, don't test it regularly. That doesn't surprise me. The 32.5%, oof. I think everyone in that group has some homework to do, regardless of whether you're a law firm or a vendor or whatever, in-house counsel. Wow. You need to have a plan at the very least. You need to be able to look at something when it hits the fan. So let's go back, bring up our last slide, please. So what is the bare minimum firms need to undertake? I'm going to start that one with Ian. What do you think is the bare minimum?
So it's a good point. Let me link it back to the previous point as well, because everybody held up a smartphone almost then and just took pictures of the screen. But how many of you actually have those encrypted? A few?
Yeah.
So the challenge is that most of us walk around with this little shiny piece of glass in our hand, which is pretty cool, and we get all the access to our office as well. But the biggest attack surfaces in your business are your smartphones, because they normally just VPN into the office. There's so much malware and apps that nobody can control. All the free apps, the reason they're free and the reason they want your contact address is because they're going to start taking your data. And people think that that's no real threat. So I think what can firms do? I think it was interesting to see the disconnect between the sort of disaster side of a business. I think everybody has some sort of disaster recovery plan, but maybe how do you test that? But the preventative side is never tested as well. So playing at the war games, paying for an ethical hacking organization to come in and test security and find vulnerability is key. And I don't think anybody really tests that stuff. I don't think people want to know the answer is the honest answer, because it does mean a lot of work. It doesn't matter how security conscious you really think you are, you're going to find vulnerability, and it's going to create an organizational process change. And we've just gone through a whole load of process review, for the last 2 years. Most people have anyway. So it means a lot more work.
I mean, there's no way of answering this question, is there? Because you don't know what the minimum is that is acceptable. But what I will say is that there are some good standard frameworks available now. There's NIST, there's the critical security controls, there's the UK government stuff, the Cyber Essentials Plus. There's admittedly alongside a huge amount of snake oil and lies in the cybersecurity industry, there are some highly credible, mature advisors and consultants who can help you to work through one of the good frameworks and help you to identify where you are and then get you to a place on that maturity continuum that you as an organization feel comfortable with. So there's no real way of answering it, but I would just go back to the existential nature of the threat that law firms face. And surely it is worth investing a significant amount of effort to protect yourself against a threat that is existential.
I agree. I would say, for me, the starting point is really looking at what your cyber insurance requires, what the regulators require, and again, back to what your clients are asking for. Because at the end of the day, if you're not at least meeting the requirements of your insurer, it's no different than leaving your house, leaving the door not just unlocked but wide open, having someone burgle it, and then trying to file a claim for that. They're going to ask you, did you lock the door or set the alarm? Nope. Good luck collecting on that claim. And the claim in and of itself isn't going to be, it's not going to fix the issue. I'm sure DLA submitted a claim when they had that massive attack, but there's always the potential reputational damage, which, in asking me about that particular incident, I don't think there was any way to prevent that, to be honest. But something like the Mossack Fonseca one, they've just folded, right? They're now in administration and winding down the business, which of course they are. Why would anyone ever trust their information to them ever again? They weren't even meeting the bare minimum standards, so I'm going to say those are the bare minimums, but I don't think there is an amount you can actually do that's ever going to make you fully secure. I don't know if you have anything you want to add to that, Jonathan.
No, I would agree. I think the biggest thing for me, I think as you say, it's very, if it was as easy to go, well, here's the minimum, if you do these 5 things on this checklist and you're cool, then it would be really easy. And I think for a lot of companies, I think for a lot of us, it's very tempting to throw a piece of tech at it and go, right, we'll get a better firewall, we'll get better antivirus, we'll get next generation malware or IPS or whatever it is. And it's a bit easy to kind of throw another bit of tech at it and go, cool, we're done, we've got the cool service, whatever it is. But it's about, I think it's about people, it's about awareness and training within the firm. You're trying to avoid that situation where, the information security team is laying down guidelines and the business is fighting against it because it gets in the way. You actually want people to understand why you're doing something rather than just sort of laying down an edict from on high and going, this is what you must do. And I think that's the biggest thing. It's about a culture of security within the business.
Yeah, I agree. And that's the one training. You'll never, ever, ever do too much training at your firm, no matter what, on anything, but certainly on security. I want to bring up our last poll. Well, I'll share, just give you an idea. Again, I was at a firm where we used to do penetration tests, and we had a guy come in, met with my information security officer, said, this guy who was testing, I'm going to go across the street to your firm, to the office, I'm going to get access to your data center, I'm going to remove the firewall from your data center and bring it back to you. My guy said, yep, go for it. Guy did it, went over there, came back 20 minutes later empty-handed, and of course my guy stood there smug because we had a good plan and everything. Did you press start on that too, please? Very smug. It was all going fine and dandy. And the guy said, give me a second. He made a phone call, walked back over, came back, firewall in hand 30 minutes later. All he had to do was call the security guard, say, I'm so-and-so, the IT director. I have a guy coming in to look at some equipment. Can you help him out? Gave him access right into our data center, pulled it right out of the rack, brought it back to us. You find where the weakest links are by testing this stuff. And that, it doesn't matter what technology you have, people are always going to be the weakest link.
Yeah, just while the poll's finishing, I think particularly large organizations, it's really related to the Hong Kong question that was asked earlier, should be thinking about resilience to attack. So yes, a lot of effort should go into preventing a cyber attack, but as much or more should go into introducing resilience into the organization so that if one part of the organization is compromised, it does not lead to other parts of the organization being compromised. And the big word in cybersecurity design this year, and I'm sure for coming years, is segmentation. So think about segmentation in all its forms at application, network, and device level.
And that will have to be our final note, Mr. Chairman, seeing as we got the time out there. These stats really don't surprise me at all. I'm going to say that 30%, I hope you already have a robust budget of some sort in there. But otherwise, I'm going to say thank you to our panelists for your time, and thank you to everyone for not falling asleep.
Thank you.
Thank you.
And we turn it back over to you.
Okay, it's lunch. Someone tell me what time it says in the timetable.
I don't think it's lunch yet. I think you have someone else.
You're quite right. We have a Tessian session, I think, next. Yes, is that right?
Yeah, that's right.
Yeah. Here he is, my good friend from Glen Eagles.
How you doing?
Okay.
There's 2 more sessions, I think.
I'll work it out when I sit down.
All right.
Thank you. Over to you.
Cheers. All right, just bear with me a minute to plug in here. Could we change this over to the next screen? Perfect. Great, thanks. Hi everyone, I'm Ben and I'm head of the legal sector team at Tessian. We're a team of data scientists, engineers, ex-professional service employees, mostly ex-investment bankers and lawyers now, all working in the world of information security. So my plan today is to talk to you about the #1 way we all communicate with our clients. For some of us, it's the #1 thing we spend most of our day doing. Some people might be doing it right now. It's emailing. More specifically, I'm going to focus on the most prevalent risks relating to email and analyse how technology has historically been used to tackle these risks, but ultimately how it's failed. I'll then look at how machine intelligence can be applied to mitigate these risks nowadays. And at the end, I'm going to predict where I suppose the next steps are for machine intelligence, where I think its application is next most necessary. So that's more my forecasting. So if we begin by just looking at email generally, and how it's impacted our lives, we consider, broadly speaking, it's been very good. It means we can work everywhere all the time, and so we don't have to be in the office to stay on top of things. Although that's also very bad. It means we end up working everywhere all the time, perhaps at times where we shouldn't or wouldn't usually be working. And improvements in the accessibility of email, thanks to mobiles, tablets, and increased connectivity, mean that we can now truly always be emailing. And it's seeing a shift of patterns as well. So nowadays, I think as of last year, 55% of emails are now opened on our mobile phones. So it's shifting in terms of that effect. And despite these increases in the collaborative platforms and new technologies that are coming out, like Slack, Teams, and then messaging platforms like WhatsApp and so on. All of these claim to potentially be disrupting email, but it's still on the rise, both in terms of the number of accounts and email volume. It's both increasing. So today I'm not going to analyse how it's impacting, I suppose, society in general and our working lives, but these shifts are relevant because they've exacerbated age-old issues that have always existed with email. So they're now much worse. So when we look at the world of information security, and email security in particular, most people seem to focus on the malicious risks. There's hacking, ransomware, malware. We've talked about a few today. Yet, here are the ICO stats from last year. For those of you who don't know, the ICO is the public body that we report data breaches to as they occur, and in return, they report quarterly and annual results showing what data breaches have been reported to them. So these are 2017's figures, and we can see that emails sent to the incorrect recipient, i.e. misaddressed emails, was the #1 incident reported last year. So I'm going to question today, how can this be? How is it still the case that something so basic is #1? And I think there are two reasons for this relating to technology. So the first is that most firms have no technology in place to prevent this issue. The second is that there's been no suitable technology that existed to actually prevent it. So we handle them one by one. If this comes back on. Here we go. So the first one here, firms having no technology in place to mitigate the risk. Now I thought this was worthy of its own slide, because really it is quite surprising. I think if we were to map out all of the cybersecurity systems available to a large law firm or investment bank, probably looks something like this. We can see things like endpoint security is now so vast, it's split out into subcategories. So firms are spending all this money building this fortress so no information can be lost. Yet anyone can still send an email to any place. It seems a bit bizarre. But this brings me to the next issue, which is that no suitable technology has existed. So I want to walk through how this technology has looked, how it's developed over the years, and then we'll apply a machine intelligence approach to show how it looks now. So in its most simple form, it's a pop-up. It's a generic pop-up. It comes up every time, and it asks the user to double-check what they're doing. Now, I'm not going to spend long speaking about this. I think the reality is we know that they don't really do anything. If somebody sees something every time or too frequently, it doesn't impact their behavior in any way. So what would be better is if it was a pop-up sometimes. That's part way towards solving the problem, which brings me to the next solution here, which is DLP, or data loss prevention. Traditionally, DLP has been used as a set of rules. So the idea is you can identify what risks a firm faces and then predict or look at data to see what keywords indicate those risks are about to lead to data breaches, and then set up rules to stop that happening. So there's a few assumptions there, but if we go through an example, you could, for example, set up a rule to try and warn when sensitive information is being sent over email. So that's just a subset of the emails. It's less disruptive. The problem is, what is sensitive information? What rule do you choose to classify this? And this is where traditional DLP is fundamentally flawed. So the idea is, even if you have someone with enough time to identify all of the risks and then guess the keywords, there'll still be a lot of gaps there, and so it won't work. And in fact, these failings of traditional DLP, using rules in general, brings me to the next age-old email issue I want to discuss, which is unauthorized emails. An unauthorized email is simply when somebody sends sensitive information to their personal account, i.e. their home account. They come in two forms, broadly speaking. They're malicious or they're innocent. So an innocent unauthorized email is when somebody sends something sensitive home with no malicious intent. So maybe Citrix is down, or they need to format it at home. Whatever the excuse is, and there could be many, the end result is sensitive information ends up outside the firm's secured environment. So the firm can't track that information, they can't ensure its deletion. For subject access requests, they wouldn't be able to comply. So lots of, I suppose, relatively new problems from a GDPR standpoint with this. But the scariest side of it is the malicious unauthorized emails. So this is when somebody sends something home on purpose, I suppose, because maybe with a lawyer they're thinking of moving firm in the next year or few years. They start to send this stuff home. It's bound to be of value to them in the future. And I think you could even argue that now with increased job mobility, this is a more prevalent risk. I mean, gone are the days where you used to have a lawyer qualify at a firm and stay there till they make partner. I think average tenure now, I was looking for a stat here, which is from the US, but it's around 5.5 years for legal occupations in general. So I want to show how traditional DLP has failed to tackle this as a problem. And I think this is the most simple way to show this. So obviously we need to be able to identify the unauthorized accounts. What do these accounts look like so we can stop the wrong information being sent to them? The problem is they don't necessarily have to be Gmails, Hotmails, or Freemail at all. In this particular example with Alice Foster here, we can see she set up the domain foster.com, which is normal enough. John is then presumably her husband, and then she also has a Gmail and an NTL World account. And there's a whole host of options that could be on the back of this. The idea is, what set of policies or rules do you set up to identify these accounts? And the answer is there are none. There's just too many options. They could be clients or they could be unauthorized. So this is where machine intelligence can be applied, broadly speaking. And the idea of machine intelligence is historical communication analysis can be performed to look through on an individualized basis. For example, with a law firm, who has each lawyer emailed before? Who have they CC'd on these emails? What have they discussed with these people and when? So I suppose it's sort of building up a social map of what looks like normal email behavior, and the premise is it can then begin to detect statistical anomalies from this that might represent data breaches. So if we tackle these one by one, first I just want to demonstrate a bit about this intelligence. So this slide here is just giving an example of a subset of the analysis that machine intelligence could find. So for this particular lawyer, again, Alice Foster, she's been in communication with 4 people called Charles or Charlie in the past month. They've each been given different connection scores based on how frequently they're emailed, how recently they've been emailed, and then what sort of stuff is discussed with them. So is it matter relating or is it just casual chat? And who's on CC or BCC on those emails. So I'm going to show how this information can be harnessed to prevent misaddressed and unauthorized emails, but it's worth quickly mentioning also, this could be harnessed in other ways. And it's not being done yet, but this could be leveraged to help clients improve their relationships with their law firms, or sorry, vice versa. So if you imagine if a law firm had access to see which relationships were strongest and which were weakest, they could understand how to improve them, and it could be very helpful. But if we start now with the misaddressed email problem, so how can this analysis be used to prevent a misaddressed email? So the idea is someone could click send, and instead of a pop-up just immediately coming up, it could instantaneously analyze the email, looking through a few parameters. So we'd look at who is this lawyer emailing, who are they CCing? Is this normal, firstly? Is this normal based on what they've done before? It could then layer that with some content analysis. Is it sensitive content? Is it content that these people have been privy to before? So it's building up the intelligence here. It can go so granular as to look at how the person is greeted. Is this what they're usually called on email, or is somebody else usually called by this name? And what's being attached? So the idea is this could all be done instantaneously, and if something statistically deviates from the norm, then a warning could be shown to explain to the end user why it's believed to be, say, a misaddressed email, as in this case. Now, if we just compare that warning to the initial one we saw, so the pop-up every time essentially is putting the burden on the end user and just saying, are you sure? Every time, are you sure? The idea is you probably come up with a shortcut to skip past that. Whereas the machine intelligence approach can only warn when a mistake is about to happen. Statistically, that's probably around every 500 to 1,000 emails, dependent on the firm and the lawyers and so on. And further to this, it can explain the logic behind the warning. So it's not generic anymore. It can actually explain why they're seeing something. So the idea is you're mitigating a risk in an acceptable way to the end user. It's not causing any frustration whatsoever. So if we now go back to the unauthorized email problem I initially touched upon, as a reminder, we can't use rules here because there are too many options. So there's too many options for what an unauthorized account can possibly look like. And so machine learning can be used to basically identify these accounts out of all accounts based on how they're communicated with. So the premise here is there'll be different patterns when emailing unauthorized accounts as there will be to clients or actual legitimate accounts. So if we look at 3 parameters, and there'll be many more to this, but reciprocity, node, and communication analysis, I think the most easy 3 to grasp for the sake of this. So we could imagine with reciprocity analysis, this is the direction of email flow. With an unauthorized account, it'll mostly be one way. It's not as interactive. People don't reply to themselves as much as, say, a client might reply. It could then look at node analysis, which essentially looks at who else is connected with these accounts in the network. And by definition, an unauthorized account will be an outlier, so there'll be no other connection points. And finally, it could use natural language processing to look at the communication itself. So the idea here is surely people speak differently to themselves, i.e. their personal accounts, as they do with a client. For example, if I email myself at home with an attachment, I wouldn't put, "Dear Ben, please find attached." So there's no salutation, there's no greeting. It will look at how I'm addressing that email, and it could be forwarded. So these sort of things can be used to identify the list of unauthorized accounts out of every account in the firm, and then stop sensitive information from being sent to them. So that's essentially how machine intelligence can be used for unauthorized and misaddressed emails. And I wanted to change this up a bit and essentially guess where next for machine intelligence. So we've looked at how this approach can disrupt and improve on rules-based approach, which was fundamentally flawed. And in my opinion, the next problem here where this will be necessary is phishing. So phishing, I suppose very broadly, is just where someone purports to be somebody else over email to gain access to key information. So it could be a credit card number or a password. And these attacks are growing more and more sophisticated. At the moment, they're still way down on that ICO list, but I imagine they'll probably creep up. If we look at what technology is currently out there, it's in the form of user training, which should probably continue, or rules-based technology that essentially is based on keyword analysis or drastic deviations from the norm, so very kind of big rule sets, to spot when it's not the person they're pretending to be. So the idea is, because it's rules-based, there's too many gaps, too many things can slip through the net with this. And so I think this will be the next application of machine intelligence in email. It's worth saying, actually, no, this doesn't yet exist. Hopefully it's imminent, and we'll see where it goes next. But I think that will be the next pain point. So I think that's pretty much everything I've got time for today. The two main takeaways, really, to go back to the start. The first is just the importance of using statistical evidence rather than human perception in evaluating risk. And I think we've heard this in different words already today, but it's this idea that it's very easy to read the headlines and just try and solve the most scary stuff. So maybe be reactive to what is happening to the peers around you. But the reality is it should be embedded with statistical research. And obviously with the ICO publishing data, it makes it much easier in the UK. The second point is just to emphasize really the importance of actually finding suitable technology for each risk. I think, as we've shown in the historic analysis here, what's been used previously, it's very easy to shift the burden. So a pop-up every time is just saying to the end user, you've been warned. If you skip over that, even though you see it every time, it's your fault. Or you could say, well, let's use some rules, and this can sit with IT. They can set up the rules, and if it goes wrong, it's their fault. Ultimately, neither approach works. They don't actually mitigate the problem. So I think there's a need to step back, analyse the risk, and then evaluate if a technology exists to support that. That's everything from me. Thanks for listening. Any questions? We got a minute or?
Take a question.
Yep.
Steve.
How do you know it's working? What's the proof?
Yeah. So that was just how do you know if it's working? So we're hearing this, I suppose, a lot at the moment. Machine intelligence or machine learning algorithms are a bit of a black box. What are they actually doing? In our case, and I suppose different companies have different difficulties here, we have a reporting panel. So we actually just show our clients what we've caught, say, on a month or weekly basis. So specifically an ROI can be calculated. So I think we demonstrate through actual examples, but it's definitely hard to draw up that sort of reporting. Yeah. Anything else? No, that's it. Thanks.
Ben, I am going to guilt you. Fantastic. Thank you. Thanks, Ben.
Cheers.
That was a very information-rich session. You managed to get through a lot of very useful content there in such a short period. Thank you, Ben. So it's Richard Mabey of Jira, who is our final speaker before lunch. Richard, you've already been trailed, I suppose, so I hope it's going to be good. So the floor is yours, sir.
Thanks very much. So I'm Richard Mabey. I'm a former lawyer. So I was originally with Freshfields, and now I'm a co-founder of this business called Jira, which is an AI-enabled contract management platform. But I'm not going to talk about Jira, and I'm actually not really going to be talking about technology. So when Richard Tromans hosted his panel this morning, one of the themes that came across was you've got to know what your problem is before you apply the technical solution. And I'm going to talk a bit today about an emerging buzzword in the world of legal tech, which is legal design. So we're going to cover what does that mean, what is legal design. We're going to look at specifically why do we think legal design matters for practitioners, both in law firms and also in-house. And I'm going to show you legal design in practice, so what we ourselves did at Jira in a specific case, which is a redesign of our privacy policy ahead of everyone's favourite date, GDPR Day. We're going to look then at, well, what about the real-world constraints? So if you're an in-house counsel, if you're at a law firm, how do you actually make this design thing happen? And finally, a toolkit, which will help you get there. First question is, what is legal design? It's kind of hard to know because there are around 5 academics in the world who focus full-time on it. The first is Margaret Hagan, who leads the Center for Legal Design at Stanford University, and she says legal design is an innovation approach. Well, pretty general. When we look at Stefania Passera, who's a legal information designer, if you can believe such a thing, legal design borrows design thinking and doing. And design thinking is a concept pioneered by IDEO and later Google, and is applied very broadly across professions. If you look at a real practitioner here, so this is Emma Jelly, who was GC at Onfido until recently. She says it's a collaborative, multidisciplinary approach. Lawyers not flying solo, and we'll come back to what that means. And finally, if we look at Antti, who's a legal designer based out of Finland, legal design revolutionizes the practice of law by putting the user at the center of the action. So legal design has a few different strands to it, and hopefully we'll bring out what that means as we go. But kind of more importantly, why does it matter to you as practitioners? Well, there are a few trends. I think Deloitte recently put out quite an interesting report about trends for in-house, and broadly you can apply some of those principles into firms. But certainly there's cost pressure. So there's a pressure to do more with less. There's also a problem where people are buying technology solutions that ultimately never solved a problem for them. And then finally, what was really interesting to us at Jira was, if you read GDPR, and I wouldn't recommend reading it unless you have to, but we did, if you get to Article 12, it talks about privacy notices, and it says notices must be concise, transparent, intelligible, and easily accessible. And actually, the GDPR goes on, and if you look in the guidelines, the Article 29 Working Party, they actually say controllers can't use long privacy policies that are difficult to understand or statements full of legal jargon. Well, when you look around on the internet, you can basically find a lot of terms and conditions which look a little bit like these, and these are actually real-world T's and C's from major tech companies listed in one long line. I still haven't worked out which one is the sort of magenta one on the far left, but we're onto them. So how do you actually put this into practice? So we know design thinking can be applied to legal services, but how? So at Jira, we were preparing, like everyone else, for GDPR, and we decided to look at our privacy notice, not just in the context of what needed to be included from a legal perspective, but to meet the requirements of transparency in Article 12. And this is ultimately where we ended up. And this is the summary modal you can see on our website, and it clicks through to various different parts. And you can see it's pretty short. It has diagrams, it has icons, which you would traditionally see across user interfaces just generally on the internet. But the question is, how do we get there? So what we did is we ran what gets called a design sprint within Jira. And there are various stages to this. It pretty much always starts with one thing, which is defining the problem you're trying to solve. And so we set ourselves an ambition to build a privacy notice that you didn't need a law degree to read. Privacy notice, don't need law degree. These were the principles we set upon. We set up a team which actually had 5 people in it. So we had our external counsel, we had marketers, content writers, designers, information designers. And so it wasn't, as Emma Jelly says, lawyers flying solo. This was a collaborative approach. And then we did something which, as a former lawyer, I find kind of strange, which was just being a bit creative. So we threw some ideas out there, what could work, what couldn't work. We looked at some design patterns, so for example, icons, for example, layering of information, the kinds of things we actually see all the time online, but very rarely in legal docs. And then we asked our users. So we had 5 users who tested the document. One was the GC of Estée Lauder Europe, so someone with a lot of legal context and information. Some were people who had absolutely no legal experience, but were just visitors to our website who volunteered. And this gave us what these thin lines are, which are feedback loops. So as we continued to learn what good information design was, we updated the policy accordingly. And that final loop, when we say release, when we release the policy to the public, is not closed. And actually on our privacy notice, it says if you have any feedback, email us at support@jira.com, and people do, on average, twice a day. So we get a lot of feedback right now, and that helps us improve. So across this privacy policy, we identified problems to solve. So the first one we thought of as the privacy fire hydrant. And so the way we framed this was having a privacy notice that is long and filled with legal jargon is the equivalent of offering your customer a glass of water and then directing them to a fire hydrant. And so just the quantity of information alone was baffling to a lay reader of that policy. And so our solution was what we called layering. And so you can see on the left-hand side, that was actually an early sketch by Stefania, who was our legal information designer, working out, well, what information should come first. And so we ended up with our summary modal, but also within the policy, you can see here little read more buttons, read less buttons. You can see these green tags are the legal bases on which we process data, and they click through to more information. So we really condensed it down to what is important. And if you needed more information, you could always dig in and read it. The second problem, what on earth are you talking about? This is what we thought of as, aside from the quantity of information, do people really understand the legal context and the legal concepts involved? And so we went for a solution which was fairly simple, fairly straightforward. It was the use of icons. And it's fairly easy to find an icon set to put in a legal document, but the question is, what is a good icon set? What actually enhances the meaning here? And what you can see here is a document that we actually tested with users. So we supplied multiple different icons that could be used, for example, in the who we are section, in the whose data we collect section, and just on a pure vote of hands basis, we chose the icons. And then the final problem was a bit more of a granular problem when we looked at privacy. And it was one of the major concerns given to us by people we spoke to was, I just have no idea when and where you are collecting my data. So right at the outset of that whole privacy experience. And typically what you'll see in a privacy policy is you'll see one section called data we collect automatically, and you'll have one section called data you give us, and you'll see some paragraphs of text. And when we went through our design sprints, we actually reimagined this whole process as a privacy journey. So you start when you land on a website, at which point we start collecting your data. If you become a user of Jira, we're then taking, for example, your contracts and the data that's within contracts, some of which may be personal data. You receive emails from us. You give us your consent to do marketing. These are steps in a timeline, and so we decided that one way of visualizing it was, rather than through just paragraphs of text, through a very simple diagram. So we went through this, frankly, rather painful process with 5 people, and it took around 3 months to do it. So it was a considerable time investment. And when we launched it a few weeks ago, we really had no idea how the community would react to it. So the first thing is we've just got more people reading it. And so one of the goals of GDPR fundamentally is around transparency. And so as practitioners and as people involved in this, we have this duty to help people understand what their rights and choices are in relation to privacy. And so now we are getting several thousand unique visits per week to our privacy policy, which is quite surprising because before then it was invariably 0 or 1 per day. So just a hell of a lot more engagement. The second thing is, well, this is a communication with a customer. So it's not a document purely written by lawyers for lawyers, although the legal element is without question the fundamentals of what we're doing. But we have people writing to us and saying, thank you very much for the explanation around my rights, because previously I didn't understand X. Similarly, it's a very transparent value exchange. So when we talk about getting into GDPR and we talk about collecting consent, we collect that consent for a reason, and it's so that we can supply valuable content. And so the more transparent we can be about that, the better the feeling is of people who opt in. Reduce risk of non-compliance. So arguably there is a regulatory mandate to do this anyway. It's not the primary reason to do it, but certainly if you're to truly fulfill those transparency obligations, it's important to think about it in this way. And finally, just a shift in team mindset. So I think as lawyers, it's often our job to tell people no. This is quite an interesting and positive way of engaging with an internal client or an external client, depending on where you are. And it leads ultimately to a shift in mindset. So what happens if you're in-house? You don't have infinite time. You don't have infinite budget. You may not have strategic buy-in. And finally, everyone's just busy, and certainly until Friday of last week, everyone was pretty busy with GDPR. Well, what I'd say is persist at it if you believe in the benefits. There are a few things that we've seen in our clients who've run similar design sprints. One is a shift in mindset of the team. So as lawyers, failing fast, which is the mantra of Facebook development team, is kind of anathema to what we do. We're not rewarded for taking risks. We're rewarded for minimizing risk. But if you get really early in that design sprint process and you're able to create some stuff, test it, maybe see failure, and iterate before you get to the final result, you can get a better overall outcome. You're not the person who always says no anymore. The team, generally, at least in 2 of our customers, it was cited that the team was happier and more productive, and of course, complying with regulatory obligations. So in terms of getting more information on this, I mean, we write about this all the time, legal design in practice, not just what it is and this whole kind of sexy topic around doing interesting, creative things with law, but how do you actually do it? I really recommend looking at Open Law Lab, which is run out of Stanford University. That is a free set of tools, for example, design patterns, toolkits, everything that you would need to run a legal design sprint. Lexpert, again, a consulting firm based out of Finland, producing a lot of content about this right now. And similarly, .legal, another consultancy based out of Finland, which is fast becoming the home of legal design. There are some LinkedIn groups to join. This one is a personal favorite of mine, not affiliated to Jira, but it's called Legal Design for In-House. So again, trying to share knowledge and get the community involved. And then final thing is that we're actually hosting an event in October, immediately after the Legal Geek event, which is going to be called Legal Design Geek. And what's kind of surprising about it is when we started thinking about legal design, typically the kind of turnout in the audience was between 5 and 10 people. There are 500 people coming to that event, which indicates to us that this is a trend that is emerging, and it's something that we really need a clear understanding of, just as we've started to get from legal technology and artificial intelligence. So hopefully this has been a helpful, albeit short, overview into legal design. As I say, we're going to be on stand 6, so if anyone wants to talk about legal design further, come and find me. Otherwise, we possibly have 30 seconds for questions. 1 minute for questions. Any questions? OK, I think it's lunch. Thank you.
I have a question for you, Richard.
OK.
Why are you not wearing socks?
Well, actually, I noticed there's a stand where someone is giving out free socks, and I've been told by my marketing manager to go there immediately. So.
You should have gone there half an hour ago. No. Thank you very much indeed. An excellent talk. Thank you. OK, cracking morning. Chance to refuel, get the blood sugar levels up. You've got an hour and 5 minutes. We are back in here at 2 o'clock. We've got quite a big afternoon, but you do get another hour's break during the course of the afternoon. So please be back in here promptly for 2 o'clock for the Customer is King session. Thank you.